Good morning, Mr. Child. So you're charged with assault of a family member. You're facing up to a year in jail and a $4,000 fine.
Officers were dispatched to a disturbance at 70 Carlton Woods Creekside. Law enforcement officers observed a white male sitting on the curb of Kukendall Road, arguing with his girlfriend on a cell phone. Law enforcement officers had received an additional call of a disturbance of two individuals coming from a neighborhood party. They observed the complainant and defendant to be highly intoxicated. An Uber had picked them both up, and they both started fighting in the Uber. The Uber drivers pulled over.
Fighting in the Uber?
In the Uber, yes, Your Honor. The Uber driver pulled over. The Uber driver stated to officers that the defendant was slapping and punching the complainant, who was the defendant's girlfriend. And the Uber driver had called the security officer on duty to get help with the situation. I'm sorry, Your Honor, it's reading directly.
DVD's here. I don't know if Sebastian's had a chance to even look at it yet.
Sebastian, stay close to that area. Don't come here. Stay close to that area.
Okay, sorry.
So we're just doing PC. All I've heard so far is that they're both highly intoxicated, arguing. He's allegedly punching and slapping in an Uber car. That's all I've heard so far.
So then Uber driver pulled over, called the security officer on duty, but the defendant got out and started walking. The security guard followed him until he got to the beginning of the subdivision. Then officers arrived and observed the defendant on the sidewalk. Officer tried to talk to the defendant. Once the defendant started to tell the officer, quote, "Leave me the fuck alone. You people are a piece of shit, and that's all you'll do is treat people with no respect." The defendant started walking towards the officer, dropped the pill bottles, and kept saying, "Leave me alone, get away from me." Officer asked the defendant what it was that they're trying to hide. Defendant said that that's my marijuana. Defendant was combative, telling the officer to fuck off. Officer made contact with the complainant witness, said they were a party, they both got drunk and started fighting when they got in the Uber. And the complainant witness stated that she did not feel pain. I think that's what we're at.
Do they see any visible injuries, anything of this nature?
As far as that goes, what's in the DIMS here is that the witness stated that he observed the defendant with enough force that she covered her face, fell to the floor, and that the witness observed the complainant based on her actions to appear to be in pain. Specifically, that the punch was of such a force that it caused her to fall to the floor of the vehicle and cover her face after she was punched. I think that's what we're at with that.
Again, Judge, to answer your question, there's no indication that there were any injuries at all, any marks, and as he just read, she said she did not feel pain, she did not want to press charges, and I have an affidavit of non-prosecution as well that I'm going to be getting to the state.
Yeah, so as far as bodily injury goes, of course, we don't need necessarily direct evidence. Pain can be something that can be inferred based on conduct. We understand that, a punch of a certain amount of force from a witness's perspective.
Did they get any statements from the person who saw the punch to?
Again, that was the Uber driver. And that's what the Uber driver said, that based on what they saw, the punch had enough force that it caused her to fall to the ground, covering her face.
The officer goes to interview the complaining witness, I'm assuming, and doesn't see anything?
I don't see any indication that they saw anything.
And she says, I felt okay. And I do not want to press charges.
Mr. Child, there are people in life when they drink, they're the life of the party, they're fun to be around. And then there are those when they consume alcohol, they turn into aggressive, mean son of a bitch that have no business drinking. If this is you, don't drink. You have but one life. You start racking up cases, you start racking up convictions. All you're doing is you're hurting yourself. Be nice and good things happen. You're aggressive to cops, you're aggressive here. I mean, the only reason I'm finding no probable cause is because they wrote this report completely, just utterly terrible. And it's over and over and over. But don't drink if you're going to be in jail. Really, we have enough death and dismemberment in our city now as it is. Don't be on the news. All right, I'm going to find no probable cause.
Thank you, Judge.
I speak English, sir.
Judge.
You like a translator, or do you speak well enough?
No, sir. I'm good.
All right, Mr. Ottaviano, you're charged with driving while intoxicated It's elevated to a Class A misdemeanor because of the high blow, so you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. All right.
On April 11th, 2025, in Harris County, Texas, officers dispatched to a motor vehicle accident. Upon arrival, officers observed an individual standing on the passenger side of the motor vehicle talking to several McDonald's employees. The defendant confirmed to officers that he was driving the motor vehicle that was present. Another officer verified the defendant was driving by talking to witnesses on scene who stated that they observed the defendant exit the motor vehicle from the driver's seat and was the only occupant of the motor vehicle. Let's see. The accident occurred in the 10,100 block of Hammerly Boulevard, Houston, Texas. I'm just trying to get some details on the accident, Your Honor. Officers observed the defendant had trouble maintaining his balance, slurred speech, and drowsy eyes. The defendant initially stated he had nothing to drink, then stated he had Buchanan's, but not too much. Defendant stated he had eaten a torta, but could not remember where it was from. Standard field sobriety tests were conducted with the following results: 6 of 6 HGN, 7 of 8 walk and turn, 3 of 4 one leg stand. DIC was read. The defendant consented to a breath test. 0.202 and 0.195 were the results.
Said anything about driving with anyone?
So
I know you have the admission, but
right, and they said there were several witnesses that saw him. I'm checking now to get some details on that actual accident, Your Honor.
but you have witnesses that put him driving.
Yes, Your Honor. There was officers there that saw him.
I don't know if those are witnesses or named, Your Honor. I haven't had a chance to look at the offense report.
Well, I'll give you time. This is just a probable cause hearing. You know, if it goes right. Mr. Octaviano, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, Your Honor.
Does he have a valid Texas
He does,
license?
Judge.
You cannot drive unless you have a valid Texas driver license and liability insurance in your name. If you do not have car insurance, do not drive. That is also a condition of your bond. Do you
Yes, Your Honor.
understand?
Yes, sir.
Because you have a lawyer, I will waive your appearance, but you must stay in touch with counsel and he'll tell you if and when you have to come back to court. For now, we'll have you go sign a reset. We'll have you get with pre-trial for your bond conditions, then you're free to go.
All right, thank you, Judge. And I've got one more arraignment, Judge, but I think we're waiting on DVD on that one.
Okay.
So,
Yeah. Good morning, Mr. Berryhill.
Good morning.
Sir, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 12th, 2025, in Harris County, Texas, law enforcement officers were dispatched to a disturbance call and made contact with the complainant, who stated that the defendant came into his business and was upset that a check issued to him was not good. Upon arrival, the defendant became belligerent with law enforcement officers, and complainant stated he no longer wanted the defendant on his property due to his aggressiveness. Defendant stated he was not leaving until he got his money and was advised 3 times to leave. Defendant refused to leave each of those times and was detained by law enforcement officers.
Okay. Mr. Berryhill, I'm going to find that there's sufficient probable cause to go forward with your case. Do not go back to this place. Do not have contact with the complaining witness. Do you understand, sir? Yes or no?
Yes,
Okay. Do you have the ability to hire a lawyer?
yes, I would like to have a lawyer. I would like a reset to have your lawyer.
Sure. We'll give you a reset now. I'm going to have the state create bond conditions for you. Don't go back to this business. Don't have contact with the complaining witness as long as you can comply. You and I will be best friends. Otherwise, it's just not going to go well. Do you understand? Don't pick up a new case. Don't become a danger to my city. That's all I'm asking you to do. Do you understand?
Sure.
I'll have you sign a reset. We'll have you take a seat in the jury box while I get your bond conditions. We'll have you sign it, and then you'll be free to go. Please. So can you file no contact and going back?
Absolutely, Your Honor.
You are Mr. Saran. Sir, you're charged with criminal trespass, facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Law enforcement officers received a call for service where an individual stated that somebody was trying to break into her home. Officers observed the defendant matching the description given by a caller around in the area. Officers made contact with the defendant, and he was identified by previous booking videos as well as his SPIN number. Officers made contact with the complainant on scene, who advised that the defendant was trying to break into her home. Complainant stated the defendant knocked on the front door, rang the doorbell, and looked through windows of the complainant's property. Complainant observed the defendant entering her backyard. stand on top of a shed to look into windows, and attempt to pull on a door handle to open the door.
And it's only a trespass.
Complainant has surveillance footage of the defendant on her property. Officers searched the defendant and found an unused pipe that officers' training experience indicates it was used for meth. Defendant stated he was a frequent user of methamphetamines. Defendant further stated that during an interview with officers that he was looking for items of value at the above residence in order to obtain money for drugs since he was currently out of money. And I think that the reason it wasn't charged as a burg have is because he wasn't actually able to make entry into the residence.
Mr. Saran,
Yes, sir.
since 2023, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, and now 11 in a matter of 14 months. If I find that you're using any kind of dope, I'm going to take care of it in a way that you're really not going to like it. I'm sending you now for a drug and alcohol test because I want to know what, if anything, is in your system. You're ordered not to use anything. And if I find that you do, and if I find that you become a danger to my community, I will grow a horn and tails. Do you understand?
Yes, sir.
I'm putting a GPS monitor on you so I know where you are at all times, and I don't want you out in the middle of the night.
Yes, sir.
It's time for you to stop using. I'm giving you now the opportunity to do it on your own. If you're incapable of doing it your way, then we're going to do it my way. And I promise you're not going to like the way that I do it. Do you understand?
Yes, sir.
Please appoint him a lawyer. I'm sending him now for a drug test. You were to go test, and you were to come right back. I just want to know what, if anything, is in your system.
Yes, sir.
If you fail to test, if you fail to come back, I will issue a warrant. No more PR bonds. Do you understand?
Yes, sir.
Take a seat for me. All right. Good morning, Mr. Graham.
Good morning, sir.
Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, sir.
On April 13th, 2025, law enforcement officers observed a vehicle with an expired registration and conducted a traffic stop. Upon contact with the defendant, law enforcement officers observed the odor of marijuana coming from the vehicle. Probable cause search was conducted of the vehicle and the defendant. Defendant stated he was in possession of marijuana, which was found to be 0.524 ounces of marijuana in his pocket. Defendant also stated that he had a handgun in the center console. The handgun was recovered from the vehicle. All right.
Can you run his license?
Absolutely, Your Honor.
Mr. Graham, I'm going to find that there's probable cause to go forward with the case. While this case is open, I'm ordering you not to be in possession of weapons. Do you understand?
Yes, sir.
You have the ability to hire a lawyer.
Yes, sir.
Okay, we are going to give you time, so I will have you go to Victoria, sign a reset. We are going to create bond conditions. License?
It's eligible, Your Honor.
Okay, you're not allowed to drive unless you have a license and liability insurance in your name, and that's part of your bond conditions as well. So we'll have you sign a reset. We'll have you go to the box while we get your bond conditions created. We'll have you sign it, and then you'll be free to go. All right?
Sir, thank you.
Please. Thanks, man. Sir, you're charged with racing on a highway. You're facing up to a year in jail. And I'm sorry, you're facing up to 180 days in jail and or a $2,000 fine.
Law enforcement officers observed a large group of performance cars gathered at a location and then saw two of the vehicles line up side by side and accelerate to approximately 100 miles per hour. Law enforcement officers recorded the events, and another law enforcement officer initiated a traffic stop where they made contact with the defendant, who was the driver of one of the vehicles that had took place in this outpacing contest. Defendant admitted to being in the races and stated that he never got out of his vehicle while he was at the race.
Do we have a co-defendant in this case?
They're checking now, Your Honor.
And number one, number two, does he have a license?
And check, Your Honor. So the co-defendant is not linked in our system. I don't know if they just were able to stop that one.
Right.
But I'm running his license now, Your Honor.
Mr. Barber, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to participate in these types of events again. If I find that you do, first thing I will do is I will put you in jail. And the next thing is I will take away your privilege to drive while this case is open. Do you understand?
Yes, sir.
You're not to participate in any street takeovers, racing, donuts, reckless driving, anything of this nature.
Yes, sir. Can I say one thing?
Don't. Just the only other thing I'm going to caution you is you are not allowed to drive unless you have valid liability insurance in your name as well. If you don't have car insurance in your name, you're not allowed to drive, and that's a bond condition as well. If I find that you do without, I will revoke the bond and put you in jail. You understand?
Yes, sir.
Do you have the ability to hire a lawyer, sir?
Oh, yes, sir.
Okay, we're going to give you time. I will have you go to Victoria, sign a reset. We will have you go into the jury box while we get your bond conditions ready. We'll have you sign it, and after that, you'll be free to go.
Yes, sir.
Please.
The
You were
Uber
charged with-
assault case was dismissed not because the defendant was innocent, but because police wrote what the judge himself called a completely terrible report, despite a witness describing a punch hard enough to knock the victim to the floor. When a case is dismissed due to poor police report writing rather than lack of evidence, does that represent the justice system working correctly? Or does it expose a dangerous gap where victims lose protection simply because of paperwork failures?
You were charged with assault of a family member. You were facing up
Puede recibir hasta
jail
un
and or
año de cárcel,
$4,000
hasta
fine.
4,000 dicen.
Law enforcement
Los
officers
oficiales
were dispatched to a disturbance.
van a llamada
Upon making
al llegar
scene,
a la cena
they spoke
y
with
se hablaron
the 10-year-old daughter of the
la hija
complainant,
de 10 años de la fijante,
who stated
que
that
dijo
her
que
mom
su madre
was hit in the face
le
by her
pegaron
dad.
en la cara por su padre.
The complainant
La
stated
hija
that she was
dijo
struck
que ella
in the
pegaba
head
en la cabeza
at least 3 times
3 veces
with a closed
con un
fist,
puño cerrado.
while also being
Ellos
kicked
también patalearon
on the side of her
en
torso.
la- su cuerpo.
While this was going on,
Mientras que esto estaba
the
ocurriendo,
defendant had
la
barricaded
comunidad
himself
se vio encerrado
in the children's bedroom
en el cuarto de los niños
of the residence.
de la residencia.
Um, the complainant also stated
También dijo de que
that she was dragged by her hair.
le rasuраron de su cabello.
The 10-year-old
La
child
niña de 10 años
observed all of this.
observó todo.
The victim, the complainant stated
La gente dijo de que
that she felt pain
ella sintió dolor
during this,
durante
but was unable to provide a
y
number.
se pudo dar
on a
una
scale of 1 to 10.
numeración a 1 a 10.
Yes, Your Honor.
Estaba involucrado algo. Dice así, sí, sí.
10-year-old witness did advise that the
Niña de 10
defendants
años
have been
dijo
drinking
que
some kind
había
of
dado-
alcohol.
había bebido un tipo de alcohol.
Mr. Mata Rojas, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will put you in jail.
Te voy a encarcelar.
I want you to know that I will protect every person in my county at all costs. I don't care who you are. I don't care why you're here, how you're here. If you're not in this country with permission and you go to jail and immigration finds you, they will possibly put an immigration detainer on you and you will be stuck like Chuck in custody until this case is over with.
Hasta que se acabe el caso.
Do you
¿Lo
understand?
entiende? Contesta.
Sí,
Yes.
Not to have contact with the complaining witness in this case. You're not to be in possession of weapons, and I don't want you to go within 200 feet of where she lives or where she works.
Judge,
Su señoría,
it seems like the
Parece
CW is
que tiene
going
que
to
tener-
want to protective order. I've instructed them if they do, we'll have to come to court and you'll have to see and hear from her if you
I
consider
think the
that.
allegations are,
las
you know,
alegaciones son-
There might be some self-defense allegations as well.
I get it, but all I know is that at this time, Mr. Mata Rojas, I don't want you to have contact with the complaining witness in this case. I don't care if she comes to you. I don't care if Jesus comes down and says we're having a party and she's there and they want you there. Don't have contact with the complaining witness. Do you
¿Lo
understand?
entiende?
Yes.
Yes.
Judge, if she, after like 30 days, if she wants the protective order removed, would you be open to if she comes to court?
Well, keep an open mind. I don't know.
Yes, sir.
No sé.
All I want to know is that, number one, he's not using, and number two, that she's protected and that she feels that she's not in danger.
Absolutely,
Ella no está en peligro.
So, I mean, come back in a while and then we can talk to her and we'll see.
absolutely.
But until that,
President, is his appearance waived? I know your rule, but I just wanted to hear from the court.
Mr. Mata, you have a lawyer. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Mr. Martinez, and he will tell you if and when you have to come back to court. If Mr. Martinez tells me he can't get a hold of you because you're ducking, dodging phone calls, text messages, or you pick up a new case, I will revoke your bond and put you in jail. Do you understand?
¿Usted lo entiende?
Yes.
Yes.
So we have a MOAP that has been already issued in this case, right?
Yes,
Yes,
sir.
sir.
Puesto.
There's a protective order that has been issued in this case. I would get to know it. If you do something to violate this protective order, the state can and probably will file a violation of a protective order. And that is one of the worst misdemeanor cases you can pick up. For now, we'll have you go to Victoria, sign a reset. You will then get with pretrial for your bond conditions, and after that, you'll be free to go. Thanks, Herman. Thanks for being patient. Good morning, Mr. Cummings. So you're charged with deadly conduct. You're facing up to a year in jail and a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 11th, 2025, officers were dispatched to a family disturbance call. Officers arrived and met with the complainant, who was ID'd by her Texas driver's license. Complainant identified the defendant by name and date of birth. The complainant stated that an argument occurred between her and the defendant. The complainant stated the defendant grabbed his handgun and held it in his hand as he became angrier. Complainant left the apartment due to fear. Complainant returned to the apartment and contacted the Harris County Sheriff's officers to report the incident. Officers made contact with the defendant. When officers approached the defendant, he stated, quote, "I'm not talking and I don't want to answer any questions." Defendant began to gather his things and grabbed a handgun and placed it in a fanny pack. Officers drew their guns on the defendant, and the defendant stated, "Are y'all going to shoot me? Shoot me then." Defendant complied with verbal commands and was detained.
Is the brandishing of a firearm enough for a deadly conduct? Because does he do anything affirmative? I guess.
So, yeah, and that's, I mean, I would, we're a PC hearing, Your Honor, I'd have to do some case law research, but I can see how it's charged is brandishing the handgun, putting the complainant in imminent fear of serious bodily injury. I think the reason it probably wasn't terroristic threat is because there was no word said.
Right.
It was just grabbing of the handgun.
Let's do this, Mr. Cummings. I'm going to appoint you a lawyer today so we can figure out, because, you know, we get down and dirty with every case because I want to make sure if I find probable cause, there actually is probable cause. So let's do this. I'm going to appoint you a lawyer today and I'll have him talk to you and then we'll revisit this PC hearing momentarily. Okay.
Yes.
Just take a seat, but don't leave. All right.
Yes, sir.
And we'll have you talk to him here momentarily. Okay. Good morning, Mr. Martinez. Sir, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 12th, 2025, officers observed a motor vehicle failed to signal a lane change. Officers also observed the motor vehicle's registration had expired in 2022. There was also unconfirmed insurance. Traffic stop was conducted. Defendant was identified by his Texas ID card. Defendant stated he did not have a driver's license nor proof of financial responsibility. Officers learned the defendant was not an eligible driver due to a license suspension back in February of 2024. Officers learned the defendant had 5 prior convictions for failure to obtain liability insurance on his license. Officers asked the defendant if he was aware of his driver's license was suspended, and he advised he was. However, he did not know how it was suspended, saying he was working on his SR22 and reinstating his driver's license.
Martinez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to drive. I don't care what you have to do in this life. I don't care if there's someone having a heart attack and you have to go save them. There's a burning building and you have to save 50 kittens. I don't care. If you don't have a license and liability insurance, you're not allowed to drive. This is an affidavit that you're going to be signing with me. And if I find that you do, every single time you drive, it's a contemptible action, punishable by up to 6 months in jail and a $500 fine every time you drive. Do you understand? If you want to drive, go get a license, get liability insurance, and I will be doing backflips. So happy I will be to take this off. But if I find that you do, it's really not going to go well for you. Do you understand? Yes, sir. You have the ability to hire a lawyer.
No.
I can have you fill out an application. I'll take a look to see whether you qualify. Deputy Miranda will give you an application. I'm going to have you come swear to us that you're not going to drive. I'll get you to Victoria, sign a reset, and then we'll have you take a seat. Please.
You're
Yeah. With both. No driving and then no without insurance. Ma'am, you're charged with 2 cases. You're charged with criminal mischief, and you're also charged with interference with the emergency request for assistance. On the criminal mischief, you're facing up to 6 months in jail and a $2,000 fine. And on the interference case, you're facing up to a year in jail and or a $4,000 fine. I also see she has an open warrant.
Yes, Your Honor. I see that as well.
You also are charged with, I guess, the following day, you picked up a terroristic threat. On that case, you're facing up to 6 months in jail and or a $2,000 fine. First, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Let's do probable cause and then we'll.
On April 13th, 2025, officers were dispatched to a disturbance. Dispatch stated that the defendant knocked the complainant's phone out of her hand and then left the location. Officers made contact with the female matching the description given by dispatch. The female stated that she was the victim, but she was not talking without a lawyer. Defendant gave name and date of birth, but would not provide an ID card. Defendant was detained and taken back to the incident location. Complainant stated she reported a criminal mischief on the defendant the day prior. Complainant advised to dispatch that he would later call back and report the incident, which he received video of the incident proving that the defendant had damaged his vehicle. Complainant advised today he went to the store, and when he returned, the defendant was on his porch. Complainant asked the defendant, "What are you doing here?" After you broke my window of the vehicle, of my vehicle. Complainant advised he told the defendant just to sit there while he called police. Defendant then left, but returned while he was on the phone with dispatch. Defendant knocked the phone out of his hand and caused damage to the phone. The value of the phone was $300.
And what about the terroristic?
So the terroristic threat, Your Honor, and this is the same complainant. On April 15th, officers were dispatched to a telephone harassment. Upon arrival, officers spoke with the complainant. Complainant stated that he had received a phone call from the defendant via a Google phone number, threatening to shoot up her home. Complainant stated she was confident the caller was the defendant and expressed her desire to pursue criminal charges. Further investigation revealed the defendant had been arrested at the same location on April 13th for interference with an emergency call and mischief. She was out on bond for that incident.
Should be given conditions not to go back.
Let me check here.
Ms. McKnight, I'm going to find if there's probable cause to go forward with the case. I don't want you to have contact with this person.
It's not for them. I'm praying about that person.
I don't want you to have contact with this person. Do you understand? Or you understand?
Yes, sir.
Okay, I don't want you to go where this person lives. If you do, it's not going to go well. I will revoke your bond, put you in jail. Do you understand?
Yes, sir. I have evidence for all that.
And I'm going to give you a lawyer today. I know that there's 2 sides of the story. You can give your side of the story you can give your side of the story to the lawyer, but I don't want you to have contact with this person. That's it. Do you understand?
So when it comes down to the child, do I have to come back to court just to get in contact with him?
I don't want you to go to his house.
No, I'm talking about do I have to come to court so I get in contact with him because we have a child.
We'll figure that out. Let me get you the lawyer and then we'll figure that out. But just don't go to the person's house. Don't have contact with him. Don't call him. Don't use anybody else's phone to contact him. It's not going to go well. You need to understand that if I revoke your bond in these cases and I set them at $5,000 to $10,000 and you don't have anyone to post those bonds, you will be stuck in there until these cases are over. Do you understand?
Yeah.
Okay. Deputy Miranda, do you mind? You know what? Don't even worry about it. I'm going to appoint you a lawyer today. I'm going to have you sign a reset with Victoria, and then we'll have you take a seat in the jury box. I'll find you a lawyer. Don't leave until you sign our bond conditions. Okay. Mr. O'Neill. Morning. Sir, you're charged with terroristic threat of a family or household member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. All right.
Good morning, Judge. Just 1 second, pulling up right now.
Okay.
So,
I thought I was supposed to have an attorney here today.
Did you hire one?
No, the judge that I talked to said that I could have.
That was for purpose of magistration, but it doesn't carry with you until the end. You don't have a lawyer at this time.
all right, Judge. On April 12th, 2025, officers responded to a family disturbance call in Harris County, Texas. The officer ID'd the complaining witness by their Texas ID card. The complaining witness stated that the defendant threatened to shoot her. The complaining witness ID'd the defendant by his Texas driver's license. The complaining witness stated that she is the defendant's daughter and they all live together in their grandfather's residence. The complaining witness stated that the defendant threw her clothes outside. The complaining witness stated she asked the defendant to go get them. The complaining witness stated that the defendant stated, "I have something else for you," and then took his hand and pointed it at the complaining witness, stating, "I'm going to shoot you." Complaining witness stated that they were in fear due to multiple guns being in the house and the defendant having a violent history. The complaining witness stated she observed the defendant holding a black long gun. The officer detained the defendant. The defendant refused to ID himself, repeatedly stating, "What is going on?" The Miranda rights were read. The defendant denied all allegations and stated his daughter, the complaining witness, was lying. Defendant advised that he hadn't seen the complaining witness all day long because she was at the hospital visiting her mother. The officer inquired about this, and the complaining witness stated that she did not go to the hospital. It was only her grandfather who went. The complaining witness stated that she was home and the defendant did see her and threaten her.
All right, Mr. O'Neill, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with this person and not to be in possession of weapons. These are your bond conditions. If you violate these conditions, I will revoke your bond, put you in jail.
Absolutely.
Do you understand?
I don't have.
Just don't say anything at this point. Just don't have any weapons. Don't have contact with this person. There's a protective order that has been issued in this case. I would get to know it. If you do something to violate the protective order, they will potentially file additional charges against you. Do you understand?
Yes.
Okay.
What about the house? That's where all my stuff is at.
What I'm going to do is I'll appoint me a lawyer today. You can talk to the lawyer about what's going on, but I'm going to do everything in my power to protect everybody in this at all costs. You understand? Okay. So look,
She can go wherever she wants, but I'm just asking.
let's do this. Let me appoint you a lawyer. You can talk to the lawyer and we can go from there. Now is not the appropriate time to go through this.
I've been staying at a shelter
Okay, hold on.
and
I already have an application. So Vic, do you mind appointing him? I already have an application on file. For now, what I'm going to have you do is I'm going to have you sign a reset with Victoria while you take a seat in the juror box while I find you a lawyer. We'll have you talk to this person and we'll go from there.
the reset happened in a few days.
We usually do like a month.
Months.
I'm going to have you talk to a lawyer today. Good morning, Mr. Schaefer. Sir, you're charged with aggregate theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. All right.
Thank you, Judge. The officer made contact with the loss prevention officer of O'Reilly's Auto Parts, who stated that he received an anonymous online tip about a possible theft regarding one of the employees from the 3498 FM 528 location. That's an address. The tip stated that the defendant had made 2 fraudulent returns and kept the money from them. The first return was back on August 2nd, 2024 for $316.50 for three brake rotors. The complaining witness was able to contact the customer and they advised they did not return the rotors. The other return was on January 16th, 2025 for $179. The complaining witness contacted that customer and they also advised that they did not return the product. The total of the 2 returns was $495.50. The defendant admitted to the theft in a written statement. Complaining witness provided the 2 fraudulent receipts and listed on each was Schaefer's unique counter number.
Okay. Mr. Schaefer, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have contact with this O'Reilly. There's not a specific complaining witness, right? So I'll just go into O'Reilly's. Do you understand?
Yes, sir.
Okay, if I find that you do, if I find that you pick up a new case, it's not going to go well. Do you understand? Do you have the ability to hire a lawyer?
Sorry, I do that.
Okay, we can have you fill out an application. I'll look to see whether you qualify. Deputy Miranda is going to give you an application. I'll have you go to Victoria, sign a reset. We'll have you take a seat. We're losing spots.
I only got one more minute and I'm supposed to.
Okay, well, there's one.
Bond conditions.
Okay, so we'll do all that. We'll have you take a seat there and then let me start. Okay, please.
I'll just call up the next one that could be ready. That is fine. Theo, come on up.
Sir, you're charged with evading arrest or detention and theft. On the evading arrest, you're facing up to a year in jail and or $4,000 fine. On the theft, you're facing up to 6 months of jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 11th, 2025, officers were dispatched to a theft in progress call in Harris County, Texas. Officers were given a description of the defendant by an Academy employee. The officers observed the defendant walk out of the store passing all points of sale. The officer attempted to detain the defendant for investigation for the alleged theft. The defendant initially complied with the officer directives. As officer grabbed the defendant's wrists, the defendant began to pull away and evaded through the parking lot. The defendant eventually tired out and officer detained him without incident. The defendant evaded approximately 1,271 feet. The officer confirmed with the reportee that the defendant detained was the one who stole a paintball gun, and officer located the merchandise in the bushes at the Olive Garden where the defendant stated he dumped it. Initially, the defendant denied taking anything from the Academy, but when confronted with being told store cameras caught him in the act, he admitted it and led the officer to where he dumped the paintball gun. The paintball gun was retail priced at the store for $140.
Mr. Steele, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to go to any academy. Do you understand? How old are you, sir?
17, sir.
Are you here with anyone today?
Yes, sir. I'm with my sister.
I'll appoint your lawyer today. All
Yes,
right.
sir.
Don't get in any more trouble. I don't want to have to put you in jail. You know, if I put your bond at $5,000 to $10,000 and you don't have anyone to put that kind of money up, you'll be stuck like Chuck, man. This is not a good way. All right.
Yes, sir.
So what I'm going to do is I'm going to have bond conditions created for you. Don't get in any more trouble. Don't go to O'Reilly's. What are you doing with yourself? Are you in school? Are you in high school?
Yes, sir. High school. I'm in 10th grade, and I'm trying to find a job right now.
School. That should be your one and only gig, you know? That should be your full-time job because the most, you want a paintball gun? Money. You get money with knowledge. You get that with school. That's your full-time job. Do you understand?
Sir.
All right. I'm gonna have you sign a receipt, Victoria. We'll have you just take a seat in the juror box while I find your lawyer, okay?
Yeah.
Please. Good morning, Mr. Garcia. Sir, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On June 7th, 2024, officers were dispatched to the complaining witness's residence and met with JV, a minor. The defendant is her older brother. They were having an argument because someone went through his items in his room. The defendant kicked her in her midsection area, causing her to fall on the floor, and struck her with a fist several times. Her younger brother also witnessed this. She felt pain. Defendant left the location before the officers arrived. That concludes.
This is old, huh?
Yes, Judge.
This is from 2024. We're just now getting it? Is it a 2B?
Yes, Judge, it must have been a 2B. We do have another offense from a 2024 date as well, so I'm not sure what brought them in this day.
Mr. Garcia, I'm sending you for a drug and alcohol test. I want to know what, if anything, is in your system now and you're to come back. If you ever take off again, I'm going to make your bond extremely high. No more PR bonds. Do you understand me?
Yes, sir.
You are on bond for a felony as well. To keep my county safe at all costs. You understand?
Yes, sir.
I'm going to appoint your lawyer today, but I'm sending you for a drug test. You must take the test and come back. You understand?
Okay.
All right. I want to send him for a test.
Can you send these charges?
Judge, we do have a few more agreements, however, the attorneys are not present.
Okay, we'll wait. Then let
Mr.
Lopez.
Siren appeared before the court with 11 cases in just 14 months. driven largely by a methamphetamine addiction so severe he was breaking into homes to fund it. The judge's response was GPS monitoring and a drug test, not treatment or incarceration. At what point does the revolving door of bond conditions, GPS monitors, and warnings stop being effective? And should courts have the authority to mandate inpatient drug treatment even when a defendant hasn't been convicted of anything yet?
Mr. Lopez, you were charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 11th, 2025, in Harris County, Texas, officer was working patrol when he observed a motor vehicle that matched the description of a vehicle that was recently stolen by 3 armed Hispanic males. The officers conducted a traffic stop. The defendants disregarded officers' verbal commands by staying in the vehicle. The driver continued to disregard commands by putting the motor vehicle in drive and operating the motor vehicle through the parking lot. More specifically, the driver drove approximately 20 miles per hour toward Officer Martin and his motor vehicle. The driver continued to evade for approximately 2 miles until the vehicle was damaged such that it could no longer operate. Defendants were detained and a stolen handgun was located under the driver's seat. The complaining witness mentioned that he was robbed at gunpoint by 3 Hispanic males who took his motor vehicle without his consent.
Charge anyone with the aggravated robbery?
We do not, I do not see that here. I'm not sure.
Mr. Lopez, I'm going to find that there's sufficient probable cause to go forward with your case. Was this in the middle of the night? Was this in the middle of the night? I don't know what your immigration status is, Mr. Lopez. And to go to jail, the immigration finds you, and on you, and you'll be stuck like Chuck in there. I want you to understand that I'm everything in my power to protect my city.
Para proteger a los
And that you become a danger.
encuentra que usted es
It's
peligro,
really not going to go well.
eso no le va a ir bien, usted lo entiende.
Yes, sir.
I'm sending you now for a drug and alcohol test, and then you're to come right back. If you fail the test, if you fail to come back, I will issue a warrant for your arrest. Do you understand? You're ordered not to use alcohol, illegal drugs, and I'm putting a monitor on you so I know where you are at all times, and I'm giving you a perk because I don't want you out in the middle of the night.
Creo que usted está por allá afuera.
Tell me you have the co-defendants, please, so we know who they
Que tienen
are.
afuera de
Cole, the co-defendants, so I know who to tell them not to hang out with.
usted. Podemos decir con quién deben estar.
We have a couple of names here in the,
nombres
Can you just
aquí.
give me like a cause number? That'd be great.
all right, the cause number is going to be 255-956-2.
That's our cause number.
Oh, the cause number for the co-defendants. I don't see it here in the, so I'm pulling up the offense.
Is Bonilla the only co-defendant?
Bonilla and Hernandez, I believe.
Okay, I don't have Fernandez in this case.
Can you give me one of the cause numbers that you have?
Yes, Judge, I have Bonilla. The cause number is 255-9576.
Your Honor, I have Hernandez if you would like that as well.
Tiene una línea de plan.
Yes, it is.
What's the other cause number called?
It is 1911823.
So they got Hernandez on the act of assault with the evading
Yes, Your Honor.
and the evading.
Robo con agravante.
There's a problem with the Woodtree case. It looks like they put the defendant as the lawyer also as the, and I don't know if that's so they take care of. But if you want to take a look, they put the defendant as a lawyer. Mr. Luke, it's 255-9576. Mr. Lopez,
Señor López.
I don't want you hanging around with the other two co-defendants in this case.
En este caso.
Find that you hang out with them. Likewise, I will revoke your bond, put you in jail.
Revoco su fianza y lo pongo en la cárcel.
Don't
No,
danger my city. Do you understand?
ciudad, ¿lo entiende?
Yes, sir.
Okay, I want to sign now. Okay, take a seat, please, sir.
Yeah. Judge, do you want me to appoint or we wait?
Yeah, no, okay. So, no weapons, No contact with co-defendants. No using GPS with a curfew, please. The curfew is 9 p.m. to 6 a.m.
It's being corrected. They have a John or
Yeah, that's right. That's the lawyer. Mr. Melendez, I want you to understand something, that you have entered into a plea bargain with the state. I don't have to take this plea bargain, and if I give you anything more than what the plea bargain is, you'll be allowed to withdraw your plea, and we can set this case for trial. But did we send him for a test today? Did we send him for a test today?
Drug test?
It was 50 days after when I picked it up.
No, I believe we only did it on day one and you were waiting for him to be clean. But I've already gone through the evidence and got an offer from the state and he decided to accept it. I thought it was 2 months after initial setting and we are now not quite 1 month out. Because I was appointed on 3/28.
Melendez?
18 now.
Now, within 2 months, have now 2 convictions on your record. If I take this, why would we keep letting you get convictions on your record to hose yourself? You want to take the easy way out in life. That's not a good way to go, because now you are just making it all the more difficult to get jobs. You want to get funding for anything in this life, not with all these convictions you start racking up. Did you start the framing job or no?
Oh, well, he didn't like answer me the next day, but I've been doing school. And I have like every day I do it.
In fairness, I did receive emails showing that he just passed his last course and has now moved on to the next one.
So what course is that?
I went through the mental health. Now I'm in U.S. history.
It's great. You don't want to do a probation to try to keep this off your record?
I don't want to do it no more. Like I've already been coming for like 5, 6 months. I don't want to keep coming and doing it.
When you pick up cases, that's what happens.
I know.
You know, when there are half-ass approach, you get a half-ass result. Now you will end up with a second conviction. You don't want a probation. If you do it, right, depending on how well you do it, I take people off early when they do well. All you have to do is stay drug-free and do probably a class or 2. If you do that, you don't end up with a conviction on you. It's up to you.
It's a strain. It's a strain on my family. It's a strain on me. Like I have to get my mom to come here every time with me. She has work to do. My dad works.
What you would do is you would report by where you live. You don't come to court anymore if you get on probation. Have you talked to him about a deferred?
I just got the offer from the state. I did not discuss it deferred with him. When I talked to him about the ins and outs of things, he told me he preferred the idea of a time served. So that was what I asked the DA for. I did not even ask for a deferred.
You can understand that you're only hurting yourself more and more and more. You now, from now on, are looking at a minimum of 90 days in jail, any new cases that you pick up. If you get buyer's remorse within 30 days, we can talk about it. If you have a change of heart where you would want to prefer to do something else, come back and we can talk. But after 30 days, I lose jurisdiction. This ends up as a conviction on your record for the rest of your life. You can never take it off. You understand? You're charged with fleeing a police officer. You're facing up to 6 months in jail and or a $2,000 fine. The agreement that you've worked out is 3 days in jail, credit for the 2 days that you've done. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. You sure you want to do this? How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty. I'll follow you. Good luck to you, Mr. Melendez. Thanks.
Thank you, Judge.
You made it. How are you?
Counsel for Lisa?
You've not been driving?
No Uber, haven't right.
How hard is it to live in this city as big as it is without the ability to drive?
That's something you take for granted.
Sucks, right?
For sure.
That's all I want you to understand is that, it's a privilege. It's not a right. and we take it seriously, and we have so much death on the road. There are certain things in life that are just elementary. You know what I mean? You just, certain things you're just, you're not supposed to do, right? All I want you to do is recognize that and appreciate it. And that's why we do what we do. We put certain conditions on, you know, I'm happy to take them off you now. I just want you to understand that it's not a right. It's just a privilege. You want a right? Go walk. That's the right that you have. Do you understand?
No, for sure.
That's all I want. Okay? All right, man. Good luck.
Thank you very
We'll
much.
take it. Okay.
See you.
Yeah. Please. All right. Good luck, Mr. Villains. All right. Second bond violation. What am I supposed to do?
So his first one was because he picked up a new case. This one, I did speak with him. He is actively in IOP. I did show you those records at the last time that we were here, that he got involved in IOP. He is getting drug and alcohol tested at his job too. He is a Marine recruiter. He did pick up some non-alcoholic beer. A lot of them still have alcohol in them. He was trying to still hang out. I get it. He realizes that that's obviously not going to work either at this point, that we're staying away from everything. But he did go get that.
I have to beg you not to violate your conditions of bond. Am I supposed to just be happy and let you go again? You know, either you have a problem or you just don't care about bond conditions.
Yes, Your Honor. I
I just, whether you say yes, whether you say no, whether you say Your Honor, I already know, you know, I know my name. I don't. The point is that you just don't get it. And what do I need to do to ensure that you don't get it?
So I have had several conversations with him, Judge. He is taking this seriously.
You had conversation beforehand.
I understand. He is actively involved in his IOP and has been continuously going to that. He is trying to make a change. He thought that he was doing something better for himself at that point. Obviously, that didn't work out. Right after do you remember the date? It was in March, right?
Yes.
Let's see.
I have like 2 weeks left.
So, let's see.
Casey, let's do this.
He had an initial appointment February 12th, but he did go into custody at that point. So then he had to reschedule it. So the beginning of March, he got involved.
Sending him for a drug and alcohol test now.
Absolutely.
I'm sending you for a test now and you're to come right back. If you fail to test, you can fail to come back. I will revoke your bond. Do you understand?
Yes, sir.
Okay, take a seat for me.
Okay,
And then
let's judge.
just leave me your cell phone and then I'll get a hold of you.
Okay, do you want it now?
Don't speak it out loud.
Okay.
Yeah. Good morning, sir.
Yes, sir.
Sir, you were charged with 2 cases. You're charged with driving while intoxicated, second offense. You're also charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine on each of those cases. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Thank you, Your Honor. On April 10th, 2025, officers were dispatched to a motor vehicle crash in Harris County, Texas. An officer already on the scene advised the officer responding that the defendant stated that he had a firearm inside of the vehicle that belonged to him. The officer identified the defendant by his Texas driver's license. The officer observed the defendant to have slurred speech and watery, glassy eyes. The officer observed an odor of alcoholic beverage emitting from the defendant's breath. The defendant consented to perform standard field sobriety tests. The HGN was a 4 out of 6. The walk-in turn was a 3 out of 8. The one-leg stand was a 2 out of 4. And the officer located a handgun inside of the defendant's vehicle during an inventory search of the motor vehicle. The defendant refused to provide breath. A blood warrant was obtained and his blood was drawn.
Okay. Can you tell me when was the first DWI? Number 1. How many DWIs? Number 2. Number 3. Does he have a valid license, please?
The date of the first DWI, Your Honor?
Correct.
2023, Montgomery County.
Okay. What was it? Well, obviously it's due time. Any other DWIs?
No, Your Honor, but if you find it pertinent, a reckless driving from 2019.
Was it pled down?
It's, yeah, convicted on a lesser charge.
So what was the
original?
Right.
Your Honor, I believe the original charge was a driving while intoxicated.
Your Honor, running his license now, they haven't given cold access yet. It's eligible, Your Honor. The license.
You know what a third DWI is in Texas? A third DWI is a felony offense of the third degree where you're looking at 2 to 10 in the penitentiary. I don't know what is going on with you, Mr. Carrillo, but if I find that you're consuming at all, I'm now placing a restriction on your license. You are not allowed to drive any vehicle that doesn't have an ignition interlock on it. On your other ankle, I'm going to put a GPS monitor on you so I know where you are at all times because I don't want you out in the middle of the night. And on your other ankle, you're going to get a scram so I know that you're not consuming. If you have a problem with drugs or alcohol, now is the time for you to take care of it, because if it becomes a problem while you're on bond, I will do it for you and you're not going to like the way that I take care of it. Do you understand?
Yes, sir.
You are not to consume alcohol, illegal drugs, unprescribed controlled medication. If I find that you use, I will revoke both of your bonds, put you in jail, no more PR bonds. Do you understand?
Yes, sir.
I want you to understand one more thing, that I'm going to do everything in my power to protect my streets at all costs. Watch the news every single day. We have a DWI fatality in our town. It's unacceptable. Do
Yes,
you
sir.
understand?
Yes, sir.
I'm not taking away your privilege to drive, but if I find that you're consuming, it's not going to go well for you. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Pham, and he will tell you if and when you have to come back to court. For the time being, I don't want you out in the middle of the night. We can talk at a later date if things, okay?
Your Honor, with the court, you're waiving the fees.
Absolutely.
Thank you.
All right. Good luck to you, sir.
Thank you.
Right this way.
So you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 12, 2025, in Harris County, Texas, law enforcement officers were dispatched to a crash and made contact with the defendant, who admitted to drinking 2 to 3 beers. The law enforcement officer observed the defendant stumbling and leaning on his vehicle to keep his balance. The defendant stated he did not remember what color the light was when he rolled into the vehicle in front of him. The defendant refused to perform standard field sobriety tests, but consented to a breath test and blew a .211 and a .204.
Ready to be honest?
No, Your Honor. And not in this county. I'm going to check and make sure.
Mr. Hernandez, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond and put you in jail. Do you understand?
No prior DWIs, Your Honor.
Okay, does he have a valid license? You mind?
Blaze, can you check the license for me?
Yeah, sorry.
That's all right.
Mr. Hernandez, you are not allowed to drive unless you have a valid license and liability insurance in your name. If you do not have car insurance, you are not allowed to drive as well. And that is a condition of your bond. Do you understand? Darla, do you know if he has a license?
I have made ALR requests, but I didn't verify yet. No charge.
So Your Honor, I don't have there was no driver's license number in our system.
You know the driver's license number?
Do you have a driver's license?
Yes.
Okay.
I'll let you guys check to see, Darla. I just want to make sure that it's eligible to drive. Otherwise, I'm going to have him sign an affidavit.
Yes,
It's
Judge, I
not to drive.
understand.
So if you don't mind,
I did find a driver's license number.
Joseph, I see your motion. Is that all you got?
Yes, sir.
I'm signing it for you.
Thanks, Judge.
Got it.
I can step back, Judge. We can verify that. And if he does need it, I can then.
Yeah, just let me know.
Sign and everything. Okay, thank you, Judge.
Absolutely, for sure. So for now, you will get with pre-chopper your bond conditions. Don't use. You understand? Okay. All right, thanks, Darla.
I'm sorry, Your Honor.
Got it.
Okay.
All right. Okay. So we'll have you sign a receipt. You'll get pre-trial and then you're free to go. Thanks, Darla. Good morning, Mr. Baskin. So you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Thank you, Your Honor. On April 13th, 2025, in Harris County, Texas, law enforcement officers were dispatched to a stalled vehicle call and observed a vehicle in a lane of traffic with damage to the left side of the vehicle. The law enforcement officer observed the defendant in the driver's seat, asleep with the vehicle on and in park. The law enforcement officer then woke up the defendant and noticed a strong odor of alcoholic beverage and glossy eyes. The defendant admitted to drinking one alcoholic beverage. Standard field sobriety tests were conducted, 6 out of 6 on the HGN, a 1 out of 8 on the walk and turn, and a 1 out of 4 on the one leg stand. The defendant refused breath and a blood warrant was obtained and executed.
Any prior DWIs?
We have one that was dismissed in 2020.
You look at every full NCIC. Does he have anywhere else?
Yeah, let me see. I'm not seeing any other DWIs here.
I see a prior obstruction. Was that reduced? A DWI reduction? Mr. Baskin, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, it's not going to go well for you. Do you understand?
Sir.
I'm not asking for much.
Oh, yeah, Your Honor, regarding the obstruction, it was just a conviction on the charge that was filed on him, just for obstruction.
Any other DWIs anywhere else?
No, Your Honor, it's not the one, other than the one that was dismissed in 2020.
Okay. Interlock or no interlock?
Judge, to be honest, I mean, he technically has no DWI criminal history. I did not represent him in 2020, but he did pretty well on the field sobriety test. He's claiming to have 1 drink. I know that, he was 1 of 8, 1 of 4.
So, it was a car wreck. I was knocked out.
Listen, if I find that you're using anything,
Yes, sir.
not only will I put you in jail, but I have a whole host of devices, gadgets that are so damn invasive on you, you're going to think you turned into a robot. Don't use. Do you understand? All right, I'm not going to put an interlock now, but like I said, if I find that you, and I don't care what it is, cakes, candies, foods, gums, energy drinks, non-alcoholic beer, don't use. NyQuil, I don't care. Do you understand?
The excuse if it's.
For me, excuses go this, and they go. All right, you've got a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with him. He will tell you if and when you have to come back to court. If he tells me he cannot get a hold of you, you pick up a new case, it's just not going to go well. Do you understand? Okay, I'll have you sign a receipt with Victoria. We'll have you get with pretrial for your bond conditions and then you free. Thanks, sir. Good morning, sir.
How are you doing, sir?
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Eduardo Martinez?
Thank you, Your Honor. On April 10th, 2025, an officer was conducting a routine traffic enforcement in Harris County, Texas, when he observed the defendant's motor vehicle fail to maintain a single lane and strike the concrete barrier wall adjacent to the road. The officer observed the defendant driving greater than 10% over the posted speed limit. The officer observed this by pacing the vehicle for a quarter of a mile with a certified speedometer. A traffic stop was conducted. The defendant was identified by his Texas driver's license. The officer observed the defendant to have red, bloodshot, watery eyes and a strong odor of alcoholic beverage emitting from his breath in person. The standard field sobriety tests were conducted. There's a 6 out of 6 on the HGN, a 5 out of 8 on the walk and turn, a 3 out of 4 on the one-legged stand. The DIC was read and the defendant consented to a breath test. The 15-minute observation period was abided by. The breath test came back to a .139 and a .139.
Any prior DWIs?
No, Your Honor.
License?
I get a license status check.
Mr. Dyack, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond and put you in jail. Do you understand?
Yes, sir.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. You must maintain car insurance. If you don't have it, you're not allowed to drive, and that's also a condition. Do you understand?
Yes, sir.
Now, good job on having a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but stay in touch with her. She will tell you if and when you have to come back to court.
Yes, sir.
If she tells me she can't get a hold of you because you're ducking and dodging, and you pick up a new case, I will revoke your bond. All right? We'll have you sign a reset moratorium. You'll get with, reach out for your bond petition, then you're free to go.
Yes.
Thank you, Your Honor.
It's eligible?
Yes, sir.
Okay, great. Okay. Kind of strong.
Good morning, Judge.
This is Mr. Gonzalez.
Yes, sir.
Good morning, sir. How are
So you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 27 days in jail with credit for the 9 days that you have already done. You need to understand that this is a lifetime thing that you're doing today, where this will end up as a conviction on your record. It's going to be there for the rest of your life. You can never take it off. This is also an enhanceable offense, meaning if you continue to pick up these types of cases, at some point they'll hit you with a felony offense, and then you're looking at years instead of days. You understand?
Yes, sir.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you plead guilty to this offense, that's it. Let me see. I don't see it. It's all this. Yeah. So your next one could be potentially a felony offense if you pick another one up. This makes 2. Do you understand? You take a case of beer. You understand? All right. How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty. I'm going to follow the agreement, sentence you to it. Good luck to you, sir. Thank you.
Thank you, Judge.
You're charged with driving while intoxicated. Second offense, you're facing up to a year in jail and or a $4,000 fine. You also stand charged with aggravated assault with a family member. And in that case, there is a warrant and you're basically bond denied. You're being held at no bond on that case.
I'm already on bond for that, sir.
If you were, that bond has been revoked and it's now at no bond. That's why we have you in custody now. So what'll happen is we'll do PC today. We will take you in, and then pending, you'll probably hit felony court tomorrow, and then you figure out what's going on with that. So we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On April 11th, 2025, officers were dispatched to an officer assist call in Harris County, Texas. Prior to arrival of backup units, officers observed a motor vehicle driving backwards down the shoulder lane on Sam Houston Parkway with other vehicles on the roadway.
Driving backwards on the shoulder?
Yes, sir. Other vehicles on the roadway. Officers learned the following information from the investigating officers. Officers made contact with the defendant, who was the sole occupant of the motor vehicle. He was ID'd by his Texas driver's license. Officers observed the odor of alcohol emanating from the defendant's breath. Defendant initially stated he was not drinking, then stated that he was. Officers observed open beer containers in the front and back areas of the motor vehicle. Officers observed at the scene, officers that showed up as a backup unit also observed the odor of alcohol emanating from the defendant's breath in person, as well as slurred speech, watery bloodshot eyes, and swaying and staggering while standing. SSFTs were conducted, 6 of 6 HGN, 7 of 8 walk and turn. Defendant was unable to follow instructions on the one-leg stand. Defendant refused breath. Blood warrant was obtained and brought to trial.
Mr. Delgado, I'm going to find the cost to go forward with the case. I am now taking away your privilege to drive, and you are not allowed to drive. Do you understand me? You will be signing an affidavit with me today, promising that you're not going to drive. And if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and $500 fine every time you drive. Not only that, I'm now placing a restriction on your license that you are not allowed to drive any vehicle that is not equipped with an ignition interlock on it. I am sending this notice to DPS so that every single officer in the state knows if you're in a car driving and it doesn't have an interlock, you will be arrested. Do you understand?
I understand.
Not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke this bond. No more PR bonds. Do you understand?
Yes, sir. May I say something, please?
No. I'm going to appoint you a lawyer today. You can speak to the lawyer, and if there's something that they need to get to me, we can, but I have a DA here, and I don't want you to say something that could hurt your.
That's fine. I just like to put something on record, sir.
Don't. Now's not the time. Let me first give you a lawyer, tell the lawyer, give me 10 minutes.
I wasn't reversing. I was putting in.
Stop. Just don't. Now's not the time to fight your case. So what we'll do is I'm going to have you come up here, swear to us that you're not going to drive. Victoria, do you mind reaching out to the max so we can appoint Mr. Delgado a lawyer?
I just did, it's Sean.
Okay, got it. I'm going to have you sign this here, and then we'll put you in back, and then I'll have Mr. Tachi come talk to you here momentarily. Okay?
I wasn't reversing at all.
So do me a favor. Can you sign conditions before we go down? Ready?
Yes, good morning, Your Honor. I'm here on two cases that I've been appointed this morning. The first is Miss Michelle McKnight.
Okay.
I think we have to address bond conditions.
Okay.
I think there was a MOA, this is the one we talked about.
Yes, and Your Honor, I do have to correct something I said during the Wesley statement. This is just me going quickly. I mentioned to the court that on the terroristic threats and the interference with emergency assistance as well as the criminal mischief, that was the same complainant. It is not. They have the same last name. They both live at that same residence. So it is two different complainants. Both were present at the same residence that all of these incidents occurred at.
Right.
From I can read into it, the terroristic threat complainant was some sort of relative to the criminal mischief and interference complainants, either a mother or something like that. It's not the same.
Okay. I mean, the fact remains she's still fighting with everybody at the house, right? And then
Right.
do we even know if they want her back?
There's no rip call done, on it at all. I think,
like-
is there two MOAPs in place? Like, I'm confused because I was told that there's like a MOAP issue, but if there's two MOAPs that are being issued on two different complaining witnesses, or if there's just no returning to the
I
house.
haven't gotten that deep yet,
Okay,
so I don't know.
okay.
Um,
And then also she has that on the terroristic threat, I believe, she has no.
right, we need to, so there is a.
She's
bond.
GOB eligible though, I think, yeah.
I'm gonna give her one,
Okay, great. Thank
So-
you very much, Your Honor.
but I'm gonna order not to go back until we know that they.
That's fine. That's fine.
No.
She's staying at her dad's house, so for now.
And
so
then,
that's fine.
and then just, where is she? Is she here?
Yeah, she's on the live stream off, please, for her approach. Thank you.
Two very different defendants appeared back to back. A 21-year-old who had never held a job, and an older man with nowhere to go after release. Judge Fleischer offered both resources, mentorship, and second chances. Going well beyond traditional judicial duties, should courtrooms be responsible for connecting defendants with housing, job training, and social services? Or does taking on that social worker role blur the line between the judiciary and other government agencies in a way that compromises the court's neutrality?
Thank you.
Good morning, sir. How you doing?
So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. Officers were dispatched to a Holiday Inn in Harris County, Texas, in response to a disturbance. The caller reported that two white males left the property, one in an F-150 and one in a Mitsubishi. When the officer arrived, he observed a Mitsubishi, which matched the description given in the parking lot, headed toward the nearby road. The officer initiated a traffic stop and made contact with the driver, the defendant. Officer asked the defendant if he was involved in a physical disturbance, and the defendant stated yes, that him and another individual got into a physical fight, and that he got into his car to separate himself and calm down. The defendant stated he was headed toward a gas station when he was stopped by the officer. While speaking to the defendant, the officer observed an odor of alcoholic beverage, glossy eyes, and slurred speech. The defendant admitted to drinking 2 beers, and standard field sobriety tests were conducted. A 6 out of 6 on the HGN, a 0 out of 8 on the walk and turn, a 0 out of 4 on the one-leg stand. The DIC was read and the defendant consented to a breath test. The results were a .103 and a .113.
Judge, I'm going to say no probable cause here because.
What's he doing wrong? He's like trying to get away from him. He's like doing the right thing. You know?
And probable cause doesn't exist. He's 0 for 6 on the walk and turn, 0 and 6 on the one-leg stand. There is no law in Texas that a person cannot drink. Just because he smelled alcohol does not mean the person is intoxicated.
Do we have anything that he's doing, you know? Tell me what led them to him.
Yes, sir. So what led to the investigation was a caller who reported the disturbance. The officer arrived and he observed a car which matched the description that the caller
That would be
gave.
like me calling and saying, hey, this guy did this over there. The cops go, no. I mean, theoretically, would be anyone could make a phone call, make an allegation, cops go boom and just stop, do whatever they want without, no probable cause.
Thank you, Judge.
Be careful, man. There's a lot of haters out there. Don't let them get you, you know? Life's too short. All right? All right. Good luck. So, Mr. Cummings, I'm not going to make a decision. I'm going to let both lawyers brief the case so we can get more of an understanding as far as law.
Yes, sir.
As applied to your case
Yes,
to
sir.
make a good determination whether there's enough probable cause to go forward.
Yes, sir.
In the interim, don't have any weapons. If I find that you are with a weapon, if I find that you become a danger, I will revoke your bond and put you in jail.
Yes, sir.
I'm not asking for much.
Yes, sir.
You know, there's a lot of relationships that are volatile relationships, meaning ones that you're constantly banging heads.
Yes,
This
sir.
is one of those. Be careful because you could be on the losing end of that. There's a
Yes, sir.
lot of vindictive people out in this life, you know?
Sir.
Put yourself with good people, none of that happens, you know?
Yes, sir. I understand.
I'm okay with you going back, but just don't have any threatening or harassing
Yes, sir.
contact with this person. I don't care what you think is threatening or harassing, it's what she perceives. So
Sir.
is this threatening and harassing? It is, and it can land you in jail.
Yes, sir.
Conduct alone can violate. You understand?
I understand.
Okay. I'm gonna have them create the bond conditions, we'll have you sign it, and then I'll have you'll be free to go. Just stay in touch with her and she'll tell you what happens next week. Okay?
Thank you, Your Honor.
Don't leave yet. We need you to sign conditions and then you can go back. So no weapons, no threatening her.
Your Honor, if he goes down, can he go down and put money in the meter and come back up?
Yeah, just make sure you come back to sign the conditions. If you don't, I will issue a warrant.
I'll be right back.
Okay, take your time. All right, good morning, Mr. Greathouse. Looks like you have worked out an agreement where they're offering you time served on DWI. You need to understand that this is going to go on your record. It will be there for the rest of your life. Do you have a CDL? This is going to suspend the CDL. You know, and like we've talked about earlier, when you have a CDL, you're held at a higher standard to everyone else in this world. Because of that, you drive bigger machines, more dangerous, heavier weight. So if you get into an accident, it's so much worse. So the other thing that you need to understand, you pick up another DWI, you can lose that CDL for life. A second DWI conviction is a lifetime suspension of that CDL. You understand? You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal once you accept this agreement. There's no turning back. You can never, it'll go on your record. It'll be there forever. Is this what you want to do?
Sir.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I'm going to follow the agreement. It's 3 days in jail. Credit for the 2 days that you've done. You know, the idea is that we all make mistakes, right? But the idea is that you don't continue to make mistakes that you endanger other people's lives. That's why we have greater sentences. That's why we have prisons. That's why we have jails, because some people just don't get it. Do you have to go to prison to learn? You know, it's a rhetorical question. It's not, but you don't have to answer. I'm just telling you, that's why we have enhanced punishments, why we do longer jail sentences, because some people just don't get it. I mean, really, if you want to get lit, great. Take an Uber, $40, $50 it could have cost you. One button. I hope that you use it in the future. I also have to suspend your license. I'm going to do it for 90 days. That is the minimum.
Thank you, Judge.
Just be careful, man. It's not hard, right? Just, you know, if you're going to go out and get lit, if you do it, just really. How do you think? Did you say guilty?
You did, Judge.
All right. I'm going to find you guilty. I'm going to follow the agreement. The other thing is this, the reason I'm telling you about the mistake is because your lawyer is asking me to waive the fee for you. Is this above a 0.15 or no? No, it's not. Let me see. This is a $3,000 surcharge that you would normally be paying on top of this. All the other stuff that you're doing now. I'm going to waive it for you now.
Thank you, Judge.
But if you come back with another DWI, it is a $6,000 surcharge that taxed onto you. Do you understand?
Sir.
All right. Good luck to you.
And Judge, I would just submit to the court. He has taken this seriously. He's done a lot. I think he's made the start of a good recovery. So I just would submit.
That's great. But the problem is that time heals all wounds. It's fresh in you now. What's going to happen in 20 years? Are you still going to remember this in 20 years when you go out on a date and you're just, that's the rub. Are you going to remember this in 20 years? Are you going to remember this in 30 years when there's a death in the family, something that you can't overcome and you go out and you just get blitzed? You know, that's the true thing. That's what it's about, you know?
Sure.
And for what it's worth, you're doing great. Just keep it on.
I'm going to remember you. You're like that father that I never had. That will come up every time I came in here.
And that's what we do, you know, like I've got 4 great kids at home and then I've got another 2,000 kids here. Some grow up and do great. Some kids, I got to sit there and freaking, you know,
Thank you so much.
just.
Thank you, Judge. Maybe excuse me.
Thanks. So who is Piedra? That's this gentleman. All right. Good morning, Mr. Piedra. You were charged with 2 cases. You were charged with driving while intoxicated. You were also charged with failure to stop and give information. On the DWI, you're facing up to a year in jail and or a $4,000 fine. On your failure to stop and give information, you're facing up to 180 days and or a $2,000 fine. You are currently being held at no bond. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay?
Thank you, Your Honor. Law enforcement officers observed the defendant driving over a median in the road. Law enforcement officers observed the complaining witness Kirkland and witness Taylor screaming at the defendant to stop his vehicle. The law enforcement officers removed the defendant from the vehicle and they observed the defendant to have strong odor of alcoholic beverage, swaying, and red glossy eyes. The complaining witness stated that the defendant struck her vehicle, that he got out, looked at his hood, but never exchanged information. The defendant then got back in the car and drove off. The damage was approximately $300. Standard field sobriety tests were conducted. A 6 out of 6 on the HGN, and the walk and turn and one leg stand were unable to be performed due to an old foot injury. The DIC was read and breath was collected.
Go a little bit slower, Paul, because she's translating.
Yes, Your Honor. Yes, Your Honor. The DIC was read and the breath was collected. The test results were a .244 and a .234.
You said that he took off from the accident, right?
Yes,
Did I
sir.
miss that? How far did he go until they caught up with him?
See all the downs.
He has an open terroristic threat. Threat's open, right? Piedra, page 57.
Judge, it just says that the complaining witness and the witness followed the vehicle until he made a complete stop.
And then the cops arrive at that location.
Yes, Your Honor, and that's when they got out of the vehicle and began screaming to get the defendant out of their vehicle to pull over.
I think he has an open terroristic threat from 2001.
2020.
From 2021, he has an open
Yes,
terroristic
Judge.
threat. Am I
Yes,
right?
Judge.
Right? Am I right?
And he tells me that he was deported. And that's why he did not come back to court.
He's in jail on all those, Judge. I don't know why he's showing.
Why is it show inactive?
I'm not sure why.
But it is an open case.
No, well, he got picked up. He's gonna be picked up on a case. This is here. He got picked up on terroristic threats. 417.
So it is open.
Last Thursday, he got picked up on that warrant from 2023.
Wow. Okay. I find, Mr. Piedra, that you are a flight risk. I don't know that you got deported. All I know is that you have an open case from 2021. And the only reason that we have you now is because you picked up these two other cases. So I'm not going to give you a PR bond. I'm going to set you bonds on both of your cases, but I'm going to tell you now that you are not allowed to drive. I don't know if you're going to bond out, but if you do, you will be signing an affidavit with me today promising me you're not going to drive. If I find that you do, I can have a contempt hearing, and every time you drive, it's a possible punishment of up to 180 days in jail and a $500 fine. Do you understand? You were ordered not to consume alcohol, illegal drugs, and I'm going to put a guardian interlock on you. If you get out, you must obtain a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. No alcohol, no drugs, random testing, no driving. Guardian interlock. We have given you a lawyer, Mr. Piedra. It is your responsibility to stay in touch with her. If you do bond out, you must stay in touch with her. If you fail to do this again, and if you fail to come back to court, then I will make your bonds high. So I'm going to set both bonds at 5,003. And then the terroristic threat is right now set at 1501. I'll just leave it as is. And then I don't know if he's going to bond out or not, but if he does, then he will be required to comply with the bond conditions. I want you to understand, Mr. Piedra, that I'm going to do everything in my power to protect my community at all costs. I just don't want another death on the roads. That's all I'm asking. Okay. And then this gentleman is...
And this is Mr. Portillo Lopez. And he does have an immigration hold, Judge,
Yes, Mr. Portillo.
as well.
Is it under reload? Yeah, there it is. Okay, Mr. Lopez, you were charged with driving while intoxicated. You're also charged with unlawful carrying of a weapon. As part of your bond conditions, I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. If you do not have a Texas driver license and liability insurance, then you are not allowed to drive as well. I guess we'll do whatever you want to do with Mr. Lopez. Right now, he's got the immigration detainer, so I don't know if he's going to be able to bond out. So I guess we'll just give you a week or two setting, and then just let us know what you would like to do.
Yes, Judge.
Okay?
I don't know if I don't think he's had probable cause, Judge. I don't see it.
He has.
Oh, yes, okay,
I'm
Judge.
showing that. Let me see.
All right.
Yeah, they found a problem.
Okay.
April 20th. So last night at 4:54 in the morning.
Okay, thank you.
Okay, thanks.
Mr. Garcia, Alberto Garcia, he came from getting tested.
Yes.
And I believe he tested positive. Cocaine and
Weed and alcohol.
cocaine, weed, and alcohol. Cocaine, weed, and alcohol.
Is that right, guys? Test positive cocaine? I'm now going to test you like crazy to make sure that you're not using, and then the next time you will stay with me. Do you understand?
I understand.
I'm giving you the ability and the opportunity now to stop on your own. And if you're unable to, then we will do it my way. And I promise you, you're not going to like the way that I do it. Do you understand?
I understand.
You will be testing 2 times a week, so I know that you're not using it. Okay. What was the last name again?
Garcia, Alberto Garcia.
6:30.
I'm also ordering you not to have contact with your sister, not to be in possession of weapons. If I find that you have contact with her, I'm issuing it. Let me make sure there's a protective order.
The paper that I have, it says that,
It does say that.
yeah, that I can't be 220 feet.
It's already in his conditions, I think, but it's a.
The court identifies JV as a protected individual, not commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon. Harold, how old is he?
21.
Where do you live?
7298 Kingsgate.
I mean, are you living with mom and dad, or where do you live?
Oh, mom.
Okay. Does this person also live there as well?
Yes, but we don't have no contact, and I'll be out of work. And I feel since I already knew about the case that I can't be there, I'm find another place to.
I don't want to put you out on the street. Okay. Where else? I'm going to let you speak to Harold to see whether we will take off the residential restriction. Okay. But I'm going to protect every person in this county, Mr. Garcia. You have to understand that your mom or whoever in your life probably doesn't have 10 to 20 grand to get you out on a bond if you violate this. So if you go to jail, you will probably be stuck like Chuck in there until this is over with. And it takes damn near 9 months just to get a 911 tape. Do you understand?
I understand, sir.
So make wise decisions, because you get no more warnings from me. If he has nowhere else to go, I don't want to put him out on the street, or he can go back to the house with mom. But I just don't want him having contact with sister, you know, and I don't want you to pick up any new cases. You're on bond for felony now. They may very well revoke that bond as it is by you picking up this new case.
Let me talk 2 minutes, Judge. I can.
Take your time. Just if you need it, we'll do it.
Yes, sir.
But you need to sign this order for protection before you leave. Okay? Can you file no contact, no weapons, please?
I don't know what the deal is, Judge, but
What are you doing yourself these days? Are you working?
No, I'm trying to
yes,
find a
sir,
job
no,
now.
sir, to the judge, or no, your honor, or yes, your honor, to the judge.
When is the last time you had a job?
I never had one. I'm making an appointment to get my ID. It's kind of hard to get a job with the 8 months on my leg.
You haven't even tried.
I've been doing job. I can show you.
What have you done?
I've been doing job applications, but I ain't never had a job, so I don't got a good resume. So
You graduate from high school. I think the deferred is the right thing to do. You get on this probation, I'm gonna whip you up. I'm telling you now, I'm not gonna play. You will be expected to do things, and if you don't, there's a heavy price to pay if you don't. No more clowning, no more sitting on your tuchus doing nothing. We expect results. And if you just sit there and think that you're just going to do nothing and smoke weed, it's not going to happen, man. It's not. You're on a fast track to nowhere in this life, Mr. Johnson. This life sucks without money. It really does. You're setting yourself up for not a damn thing, just to become another statistic. You're not finished high school, not looking for a job. What do you do all day? What do you do?
I nothing to do. I've been looking for jobs. I made an appointment for my ID. I'm waiting to get an ID.
What do you have in your life that's pushing you to do anything good? Is mom and dad around?
My daddy passed. My mama. Yeah.
Yes, sir, or no, sir? Or
Yes, sir.
Mom or what?
Sir.
Do you live with mom?
I live with my girlfriend.
So the girlfriend is who works, who's pulling your,
Yeah.
giving you everything?
Sir.
You're okay just riding and letting the girlfriend work and just.
Nah, I've been looking for a job. I've been doing job applications.
When is the last time you've had a job?
I never had one.
Hey, so you a bum. You've done nothing. How old are you now? Okay. It stops. It stops now. You understand? I'm going to keep you all so close. You're going to think that I'm the parental figure here, because that's what's going to happen. Enough is enough. We need to get on this quick before this ends up nowhere real quick. So send it for the TRAS today, back on Monday, and I want it done Monday. And the first thing that we will do once that happens, 2 weeks to get an ID. My sole issue is protecting as many people as I can. That's what I want to do. I know, or it may come at an inconvenience to you, but I like to follow the wishes of the complaining witnesses, because I don't want them to live in fear. There's nothing worse than having to live in fear, having to walk on eggshells, and that's what we try to prevent here. And I know that you have your side of the story, and there's always two sides of the story, but the best recipe that I usually find is keeping people away from themselves. The problem is that may be a disadvantage of you because you may have nowhere else to go. But what other choice do I have? I don't know, right? Tell me, you were able to speak to her.
Yes, Your Honor, and I'll relay the message she gave me. So just a little bit of context, the defendant is her father, is what she says. And she says she's had no contact with him since the incident, but she does say she's been getting updates from family about the defendant that she's not asking for. She said that she's getting married and planning on starting a family, and her heart's desire is to have her father in her life, but she said that he's proven that it cannot happen. She states that she is done with her relationship with the defendant. The defendant has not changed. She wants no contact. She's currently working on making her restraining order permanent. She states that the defendant is not trying to get help. She states that she wants anger management, Alcoholics Anonymous, and Narcotics Anonymous treatment.
So there's drug issues and alcohol issues.
According to the complaining witness, Your Honor, yes. So we know about the situation.
Stop. Don't say anything. Just don't.
And so we know about the situation where he needs some of the items he has at his place. She says that she has them placed in bags. She says that she's either told the family to handle giving the items to the defendant, or she is okay if the defendant comes with officers while she's not present.
So she obviously lives at that house?
Yes, Your Honor.
Who, is it grandfather's house? Whose house?
I'm not sure.
I mean.
It holds the grandpa's house, his father's house. But he had actually moved in there to help out with his parents. Well, I told you, he had strokes at both times. Right?
Yeah, but I can't, she's living there and, it's.
So I'm told that his daughter is a drug user, judge, and that this happened late at night. In fact, even in the DIMS, it says that this alleged assault.
I can't really.
No, but it says alleged assault happened at 2:30, but we didn't call the police until 4, I believe. And she mentions a long gun, but there was no guns found at the scene.
I don't know. I don't know. I just don't want you to, she doesn't want to have contact with you. So don't have contact with her. Don't use any drugs. Don't use alcohol, and making that a condition of your bond as well. You know, I don't know what to tell you, but she lives there. And if I allow you to go back to that house, it's a recipe for disaster. You know?
Judge, he does live with his parents and has nowhere else to stay right now. He's been living at the Star Hope shelter for a week. In fact, they arrested him in his underclothes, and he's wearing clothes that are given to him.
Well, I mean, like you said, he can go back and get the stuff. He's got to go with an officer, and at a time that she's not going to be there. I guess we could work that out.
His ID and cell phone, all that are at the house, and they can't get that.
She has it in bags ready to give to him. You know what? Also do this. Can you, if you want to, we can roll this to tomorrow, but will you also reach out to, I guess, the homeowner and get their opinion? Are they okay with him coming back? Perhaps you can get their side as well and see what they say. So we get like a neutral and detached person to see, is this because he obviously wants to go back to the house? I mean, we know that she doesn't, but the problem is that if I let you go back to this house, you will invariably at one point or the other, you're going to run into her, and it's going to be disastrous because it always is. And then you're going to end up back in jail. You're out because we gave you a free bond right now. You need to understand that if you go back, you probably have no one in this world that's going to pony up 5,000 to 10,000 to get you out. You will be stuck like Chuck. You need to consider these things when you're out there. I'm not asking much from you. I just don't want you to have contact with this person, and don't have any weapons, and don't use. That's all I'm asking. You want to roll this tomorrow to see if there is perhaps a way that they could kind of separate, kind of bifurcate the house, so to speak?
Again, is your father able to answer the call if they call and talk to him?
No. Well, look, I don't want you guys to talk here. Let's do this. Let's roll it to tomorrow. See, do you mind reaching out? Is there a possible way to kind of divide the house in half or is there like a garage apartment, or is there like a shed or something that he could stay at? I don't know, you know, but
That's how I've been living.
You're separate from her.
Yeah, I'm separate from all of them.
We can talk about, he's telling me that he's separate, living away from everybody, his own room, I guess.
I want to hear it from them too.
Sure.
I don't want to hear it just from you. I want to hear it from them that they feel protected. That's my own concern, you know?
I understand.
So we can, you know, come back tomorrow because it's already 1 o'clock, right?
What time tomorrow?
Same time, early, 8, 9 o'clock. So
we'll be here tomorrow.
So guys, this is Mr. O'Neill. So no contact, no weapons, no going to the house for the time being, no drugs, no alcohol, random testing, please. All right, Mr. O'Neill.
Testing.
No drugs, no alcohol, and I'm going to test you to make sure you're not using. If you test positive for drugs or alcohol, I'm going to put you in jail. Don't use.
Yes, sir.
All right. Okay. All right. Good luck, Mr. O'Neill.
Thank you, Judge. My excuse.
Thank you. You were charged with 4 counts of assault.
Theft, Judge.
I'm sorry. Theft. 4 counts of theft. You have worked out an agreement that you're pleading guilty to one of those. It is 165 days in jail, but we will give you credit for the 55 days that you have done, so there's no more jail time. But this will go on your record. It will be there forever. You now have at least 2. So if you ever pick up another theft, you will be charged with a felony. Do you understand?
Yes, sir.
If they charge you with a felony, you will be looking at years instead of days. So I wouldn't do this again because you're looking at a lot of time. Do you understand?
I understand.
You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, it goes on your record. You can never take it off. Do you understand?
I understand.
Where are you going when you leave here?
I'm going to start hope. Bridge or to Spirit Key or Bridge on Muddy Waters.
You have family that's around?
Yeah, I have family that live in Hunters Glen 3. My dad
Back to them.
being an older person, I was always doing everything on my own. I go for them for resources.
If you want any help, come back here and we can help you with things. We can give you, a cell phone, tablet, place to stay, food. If you have family, perhaps they'll take you back in so you don't wander the streets. Nothing good happens on the streets. Do you understand?
Understand.
How do you plead to the theft? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I'm going to follow the agreement. Good luck to you, sir.
Thank you, Judge.
Okay, Mr. Lane.
Across 3 full sessions now, one theme emerges above all others. This courtroom is quietly fighting a war on multiple fronts simultaneously: addiction, poverty, domestic violence, homelessness, and recidivism, with the tools designed only for one of them. Judge Fleischer operates more like a one-man social safety net in a black robe than a traditional judge. He offers GED programs, promises to seal records, threatens jail in one breath, and offers a cell phone in the next. But here's the hard truth this session forces us to confront. The justice system was never designed to solve addiction, poverty, or broken families. It was designed to punish and deter. And yet, in courtrooms like this one across America every single day, judges are left holding every problem that every other institution has failed to solve. The real question is not whether Judge Fleischer is doing a good job. He clearly is. The question is why a courtroom is the last line of defense for so many Americans who needed help long before they ever stood before a judge.